Hello, I'm Rob Cartmel from ProTrust Consulting. We're here to deal with matters such as wills and trusts and estate administration and managing trusts. One of the key questions to our business that people ask is, why do we utilise trusts so much within our structures for wills? So this is just a short video to give a flavour of the reasons why we do so and the options that are available to families in particular when creating their wills. So let's have a quick look at some slides. So just briefly about our firm, we are primarily centred on trust work. So that commences with estate planning, creating wills and trusts, and then we oversee wills being administered on death, the process of passing estate into trust, and then managing that process forward with trust management. Even if trusts are dormant over a number of years, there is a degree of trust management now required for the proper and effective use of the structure. What I want to concentrate on is why we use trusts so often in wills and why people so readily want to have trusts incorporated. In a nutshell, trusts are used to provide an opportunity to the people who own the assets and want to pass them down to their chosen beneficiaries in a protected way. So they're the opportunity to protect assets for beneficiaries. It might help to have in your mind a case study, and we'll try and create a relatively straightforward case study, a common case study. But of course, every individual and their families' circumstances are different to the next person's. In this example, we have a husband and wife wishing to make wills together. They have a property asset and other financial assets. Let's say in that example, those assets are worth a couple of £1 million in all, and they want to pass their estates to each other and then down the family line to their 2 children of the marriage. So from then, they might come to me and say, our wishes are simple. They're as simple as they come. To my wife and then the children. And she would say to my husband and then the children. But they've heard a lot about whether trust wills might be suitable for them rather than basic wills. So do they need a basic will or a will trust? In that scenario, almost certainly we will be advising that a will trust is preferable, given that it provides flexibility to do a number of things or have a number of options. And I've mentioned them here: loaning, gifting, or have life interest elements for the spouses on the first death of the first to die of the couple. So let's have a look at that in a little bit more detail. What are those options and why are trusts so central to that? And this example is for married couples, but it applies almost the same in terms of the options remain the same for individuals passing their estate down to children or to other beneficiaries. And also the structure of trusts with wills can also be very beneficial when people leave their estate to charity. But I'm not going to focus particularly on that at the moment. I'm going to focus on couples leaving their estate to children. So what are the gift options? And this is a slide that I produced a few years ago, most of which is still current. This is the scale of gifts that I see available for families. On one end of the spectrum, or one end of the scale, you have an outright gift. And that's what often people come to me assuming would be the case. I leave my estate to my wife, the husband might say. So is that the best structure to ensure then that it passes down to the children in the most efficient way? So gifting to the spouse is, of course, a priority in terms of providing the spouse the full or absolute use. So you see I've put a tick there, meaning a positive in that example. It's a very generic and general approach here to this slide. With a gift from a husband to a wife, there is no protection then for the children. It's free for the wife's estate to receive that asset or that value, and then deal with it according to the wife's will. Now, of course, if they make the wills together, you'd think that the children would end up with the estate, but not if the wife then, say, remarries after death of the first spouse and then makes a new will to a second spouse. So there is no protection afforded to a secondary beneficiary, like children, when gifting to the first beneficiary. And that's when people then consider the other options on the scale. At the other end of the scale, you have rights of occupation, and more commonly a life interest. And a life interest is a more restricted use for the spouse, providing only the income. So the income is the ability to receive interest or income on financial assets, and with property, it's to receive rental income or to live in the property share rent-free. So for large estates, that will be a tick. That will be absolutely no problem. But for lower estates, that's more restricted use for the spouse. But the advantage of a life interest is it fully ring fences the first spouse estate to pass ultimately to the children. So you see the opposite ends somewhat of this spectrum: tick, cross, cross, tick. So is there a middle ground? Yes, somewhat there is. And I like to refer to this as a lifelong loan or a lifetime loan. And this is one of the key elements that we need to try and convey to our clients. I like the idea of lending the estate. Lending in full, so if the husband, say, in that example with his half share of the £2 million, has his own £1 million share, comprising half share of the property and half of financial assets, wants to lend it to his wife, the £1 million that he owns will pass across into his wife's name, but she will sign a document to say, or set of documents to say, that she owes the value back, the 1 million she's received, back to the husband's trust to pass ultimately to the children. But of course, here it says full use for the spouse. So if there's no restrictions on using the loan monies, no interest, no repayments, possibly not even any capital indexation for inflation, she could then take those monies and utilize them as she wishes. So very much akin to the absolute use when you make a gift, but it will be a debt of her estate on her death. If she spends the money, that's her prerogative. That's what the husband has said in a straight loan in that example that he's happy for her to do. And therefore, in that example, there's only what you might call a half protection for the children. It's only a debt that is reclaimable on death of the second spouse. So if the second spouse's assets aren't sufficient to repay the debt can't be repaid, and the children aren't so protected. That is where you lie in the law. You lie on three main options: giving, loaning, or life interests. And during the course of your life, as you make wills and review them, the priorities across that list can change. So the key is to have a flexible trust, a flexible structure that allows for these three things to be achieved. And there are other factors here that people like to think about. They like to think that it's protected if their spouse then remarries and it doesn't go well, that it's protected from divorce. If you gift the estate across to the spouse, there is no protection on that event. And likewise, if the receiving party is subject to bankruptcy or goes into care, those are all attackable assets if they've been received by gift. I'll mention inheritance tax separately in a minute because there are some newer rules on inheritance tax. But essentially, a receiving party, receiving assets, their estate increases, and it's thus more taxable generally. But government have brought in some reliefs, such as the residence nil rate ban and spouse exemptions that may apply. So that is a specific area that I think we need to provide some proper advice on as part of the process. But the other areas of loaning and life interests are all containing other benefits or other potential benefits. Having a life interest, just the income, means the capital might be protected for the children and against attack from things like divorces bankruptcies and care fees. And the same on a loan, because there's a debt, the net assets of the receiving party are reduced. They're not increased. And therefore, this is a very, very brief summary in this little video of 3 areas and their potential uses. But instantly that creates a visual that there may be benefits of lending or life interest creation, both of which involve the use of trusts with wills. Whereas an outright gift is very much within a basic structure. So going back to the situation I said at the top about the husband and wife having very simple wishes, those wishes can be distilled, they can be, the priorities can be overcome by the fact that these are necessities to understand, at least to understand the flexibility that a will trust offers. So that, in a nutshell, is the summary of how trust options can benefit families and protect the assets passing down to a spouse and then children. I hope that is helpful as an initial summary, and I look forward to seeing you to discuss these sort of things, and please look out for any other further videos with information. Thank you very much.